Okay, good morning. My name is Siobhan Kinsella. Delighted to welcome you here this morning to the Employment and Recruitment Federation briefing on employment law and policy outlook. We have a jam-packed session today. Like everybody else in the country, I've got a dose at the moment, so I apologise for my voice. Delighted to have with us today Brendan McGinty, who is Policy Advisor to the ERF. He's also Managing Partner and Founder of Stratus Consulting. Brendan is going to cover the domestic employment front, and we also have Michael Freytag, who's the Policy Affair Manager for the World Employment Federation, who's based in Brussels, who's going to give us the European outlook. Like most of us are incredibly busy navigating our own businesses and the domestic and European policy context, and our lawmakers deemed feel it appropriate to make it ever more complex. So without further ado, I'm going to hand over to Brendan, who's going to cover the Irish policy context, and then we'll move on to Michael. Thank you.
Thanks, Siobhan, and good morning, everybody. And delighted to have the opportunity to be with you this morning, just to give you a bit of a. It's going to be a bit of a hurried review of some very significant issues, I'm afraid, given our time constraints. But nonetheless, I hope you get value out of the session and get some pointers for some of the main issues that are coming at us in 2024. I'm going to concentrate. Really, you'll see hopefully on screen, I suppose, our agenda. But I want to concentrate in my part of the contribution really on the first kind of three issues around. The prospect now, the pensions auto enrolment may be with us in 24. We have obviously an increase in statutory sick days coming in. And we also have some important changes around leave arrangements under the work-life balance and miscellaneous provisions legislation that everybody needs to be aware of in respect of medical care leave and domestic violence leave. Before I get into some of the specifics, I think it is important to say that, look, there really is a very significant volume of changes in employment legislation and regulation that does impact, obviously, on all of us in the labour market, including, obviously, for the employment and recruitment sector. And it's really important to be aware of these issues as we interact, obviously, with clients and candidates. And to give you a little bit of a sense of the overall impact, and as part of the work that the ERF has been doing, we've been, I suppose, gradually raising our concerns about the total impact of all of these issues. And to give you a sense of that, we've estimated that the combined effect of the changes around statutory sick pay, the changes to parental leave and parents' benefit, the move towards pensions auto enrolment, and we also, for example, have in prospect a move towards living wage, that the combined effect of all of these measures over the next 10 years could be actually to increase average labour costs by about 10% or thereabouts. And I think that's obviously worrying. But we also have to recognise that we're also heading into an electoral cycle next year, where we could be facing 3 elections between European, local, and even the potential of a general election, perhaps. So, inevitably, I think we're seeing a particular spike in proposals for additional improvements in employment rights, which obviously has an attraction generally for people, and obviously is of particular interest to the political system. One of the most significant changes that we will see over potentially now next year is the introduction of the automatic enrolment retirement savings scheme. And basically what this is about is government trying to address some of the significant gaps that exist in our pensions and retirement saving systems, especially for those substantial number of people, about 800,000 people or thereabouts, who are not covered by any form of occupational pensions arrangements, and are relying on very modest savings, or indeed purely the state pension. Now, it has to be said, and it's important to emphasize that this proposal has been around. I think I first was dealing with this as far back as 10 years ago, believe it or not. But in fairness, the current government are absolutely determined to bring this about. And the full expectation is that the legislation to enable the system will be passed through the Oireachtas next year. Now, a couple of significant provisions that people need to understand are that this is going to operate on the basis of automatic enrolment. So in other words, an employee will be automatically enrolled in the scheme. They have to remain in the scheme for 6 months, but they will be free to opt out at a later date. There will be a facility, for example, to suspend or pause contributions and to leave the scheme on certain defined conditions. But even where they do, they will be re-enrolled at a later date. So the absolute policy intention here is to encourage a greater level of take-up of retirement savings across all employees who are not currently covered by an occupational scheme. I think it's also important just to stress that, look, this is going to come obviously at a cost. Contribution rates are going to be levied as a percentage of earnings based on earnings really between 20 and 80,000. And it will start at about 1.5% of gross earnings, increasing up to 6% in year 10. There will be an obligation on employers to match employee contributions, and there will be a facility, or the state will be topping up both the employee and employer contributions, and that will range from about 0.5% to 2%. One of the concerns, however, about the timing of the introduction of the scheme, notwithstanding the positive policy intent that's behind it, is, I suppose, to state the obvious, that if people are already under pressure in terms of the cost of living crisis, housing costs, mortgage costs because of rising interest rates, childcare costs, etc., and they now find themselves being compelled, let's say on commencement of a scheme of this nature, to pay 1.5% of gross earnings into this particular scheme. And even though there will be matching contributions from the employer and the state, if people are in difficult circumstances, they are very likely to turn to the employer to say, can you do more by way of pay to help me out? So obviously that's a significant risk, and it will be particularly challenging, I think, for businesses in a number of sectors. So again, I think that's just something to be aware of. It is coming at us, and that legislation and the system is likely to be established next year. Under the legislation, a central processing authority has to be established, which will be an important organisation that will be set up nationally to administer and to set standards for the scheme. Just to move on, the second issue that I wanted to speak to is around the whole issue of the changes in sick leave. So maybe to move to the next slide, Anna, if that's okay. So the changes that are happening, as people will know, for the first time in 2023, we had the introduction of statutory sick leave in Ireland. It's been in place, obviously, since the 1st of January. And the policy intent is to phase in increases in statutory sick leave over 4 years, started with 3 days in 23, 5 days is now confirmed from 2024. So we're going from 3 days to 5 days from the 1st of January. Businesses need to be aware that that will increase to 7 days in 25 and 10 days in 26. So effectively two working weeks, as you might say. And again, as colleagues know, that's applicable to those who are on a contract of employment, including agency workers, and it can be consecutive or non-consecutive days, and is paid at a rate of 70% of the wage, but the normal wage, but is subject to a maximum of 110 euro. A couple of really important things to say, though, about statutory sick leave is that it doesn't prevent better terms being applied, and perhaps in unionised environments that might be done by way of a collective agreement. And one important case actually that has arisen just in recent months, and it's the first of its kind, where there was a complaint taken to the Workplace Relations Commission in relation to by an employee of Musgraves, and basically saying that, look, they weren't afforded the statutory sick leave of 3 days, notwithstanding that they had also benefited from the terms of an occupational scheme. So the issue essentially that was in question was whether, under Section 9 of the legislation, which provides that the terms of the legislation should not apply to an employer who provides a sick leave scheme where the terms confer benefits that as a whole are more favourable than the statutory leave. So that issue went to the WRC, and in that particular case, the WRC deemed that the person was not entitled to statutory sick leave. So that's a really important case, and it's the first of its kind that certainly we're aware of, where that issue has been tested. So that will give some comfort, I think, to those employers that do have occupational sick pay schemes, as long as the benefits as a whole are more favourable than the arrangements applicable for statutory sick leave. And that's important because in the absence of that, the person could be entitled, or there could be an award of compensation of up to 4 weeks. I think that's, again, people are probably already familiar with the other aspects of the operation of statutory sick leave and the conditions of entitlement. And obviously for entitlement in the first place, somebody has to be working with you for a minimum of 13 weeks, and it is subject to medical certification. So the next area, I suppose, I just want to, or really the last point for me to cover this morning is to speak to a number of changes that have recently come about as a result of the work-life balance and miscellaneous provisions legislation. Now, that's an important piece of legislation, and in fact, it has introduced quite a number of changes around leave arrangements. But it's in the context, obviously, it's important for people to understand the purpose of the female workforce participation and promoting gender equality. And while it sets out a range of changes, those changes are only coming into effect at different times and are subject to commencement orders by the relevant minister. So in summary, what it's doing is it's introducing a right to request flexible work for parents and carers. It's giving employees a right to request remote working, and it introduces unpaid leave for medical care reasons and paid leave then for victims of domestic violence. So on medical care leave, we now have an entitlement that has been introduced of up to 5 days annual unpaid medical care leave, and that's in addition, it's important to stress this, that's in addition to the existing entitlement, obviously, to unpaid parental leave, for example, at 26 weeks for parents of children up to the age 12. That's obviously been in place since 2020, which is a separate entitlement. Now, what's interesting about this, and again, it's very early days because obviously this leave has only been given effect since July. No real evidence of cases coming through yet on this issue, but I think there are likely to be some challenges around how this is implemented, because, for example, the entitlement is extended to those who are caring for spouses, civil partners, cohabitees, and direct family members. So quite a broad range of people are potentially covered by this, where an employee is caring for others. And it's also important to stress that the legislation speaks to significant care or support for a serious medical reason, but a serious medical reason is not defined. And that of itself, in the absence of definition, of course, as we know, could give rise to some issue of contestability. In implementation, it's important to mention the employer obviously can request relevant evidence of the medical needed for the leave, such as, for example, if it's a medical cert maybe, or indeed other evidence. And obviously the person should give confirmation to the employer, obviously in writing as soon as it's practical, of the need to take the leave and so on. An important point too, maybe just a bit of detail, is that obviously if somebody is on probation or training or apprenticeship, and the person needs to take medical care leave, then the days can be added to the end of that probationary or training or apprenticeship period. But otherwise, important to stress, the leave can't be taken in periods of less than a day. So somebody can't just take a half day, for example. If they take a half day, it counts as 1 day for medical care leave purposes. There's no minimum service requirement, and they don't have to give notice if it's an emergency situation. And as I say, finally, that's in place since July 3rd. So the very last one from me before I hand over to Michael is the very recent change then that has been introduced on domestic violence leave. Obviously, this only arises in the most terrible of circumstances, where a person obviously is going through an appalling situation of experiencing domestic violence. The leave is for up to 5 days paid leave in any consecutive period of 12 months. It is through the passage of this, there was a lot of debate about the rate of pay at which this was going to be afforded. The final shakeout of that is that the rate of pay is to be at the full rate of pay of the employee. And as I say, this is now in place since the 27th of November, and it's applicable to any person of any age who's obviously in employment, including part-time or fixed-term employees. And again, there is no service requirement or indeed no requirement to give evidence in obviously what is an incredibly sensitive and difficult situation for the person concerned. But that is now in place since the 27th of November. And again, what we would do, would encourage you both on domestic violence leave and on the medical care leave, is to make sure that your in-house policies are up to date and are reflective, including handbooks, contracts, but more generally statements of HR policy around these issues to fully reflect these new provisions. So as I say, these are some of the highlights that I just wanted to share with you this morning. And I should also say to you, just as a final thought, just mentioning or just touching back on the pensions issue, is that the government have also confirmed that they will be keeping the state retirement age at 66, but of course that has to be paid for. And you may have seen as well very recently the government confirming its intention to make some adjustments, incremental adjustments, starting with a 0.1% increase in PRSI contributions and those rising incrementally out to 2028, which effectively will amount to about a 0.7% PRSI increase for the average worker over that period. So PRSI costs are certainly going to increase over the next couple of years, and that is ultimately with a view to paying for the decision to retain the state retirement age at 66, but more of that perhaps on another occasion. So I'll leave it there, and I will hand over to Michael, and if there are any questions, we'll pick them up in the chat.
Thank you very much, and very happy to be with you today online from Brussels. A lot of things that Brennan has mentioned are actually also coming up at European level, but I would like to focus on the 5 topics being mentioned here. I will start off with some sections on the EU agenda as we move into next year, and the fact that we move to elections, which you also heard from Brandon, and yeah, of course, certainly elections are always a time of setting a new agenda, but also a time of finishing up legislation. This is what we see currently in the last quarter of this year, but also moving into next year with the Parliament and the Commission coming to an end of mandate. We had quite some discussions at the European level on the different temporary action looks this year. I'll give you an update on what's happening there, also coming to legislation and jurisprudence. Pay transparency is something that is important, and platform work, AI, everything in the digital space happening. I'm trying to speak to 20 minutes maximum, 10 minutes maximum, so I will try to be brief. Next slide, please. This is our manifesto key messages, which we have developed at the WEC Europe level for the European Parliament elections and new Commission mandate. We have first a session on our vision on appropriate regulation on level that works for all. We integrate some for research project we are currently doing with actually longitude there. And then we focus on 3 main areas and topics: a social contract, a social model that works for all and protects all. Look at social protection for all, looking at portable rights, diverse forms of work, agent work, fixed-term contracts, part-time work, and trying to counterbalance and reflect on or rebut the perception of some trade unions in Ireland, but also in other parts of Europe, trying to promote our industry, employment and recruitment services in Europe. Second part is about skilling and labor market transitions. So there we look at skills investment and skill shortages. We are seeing in many countries labor shortages being a key issue. We touch on labor mobility and legal migration, but also on partnerships and career management, career services. And the final point is everything about digitalization and AI. Here we talk about platform work, the EU AI Act, which I come to later on, and the benefits of the transformation. And then we have a final section with the role of our industry and our labor markets. This manifesto is ready. It will be has been to our members in the last quarter and will be published end of January, 31st of January, at an event online, which we host from Brussels. And then, of course, we're going to continue with dialogues at EU level. One element coming to regulation, one element which we are doing at global level is a survey every year around regulation on HR service and agency work worldwide. And here you find the main finding, which is an important introduction into the discussion on the temporary agency work. You see that agency work is actually a very comprehensively and well-regulated sector, and this applies to establishment, conditions for use, conditions, social protection, and social dialogue. A few key elements: licenses are quite common, or accession schemes. Reasons for use are also common. Equal treatment, equal pay regulation is very common, also as the different abbreviations work. So it just shows that some accusations that we are seeing at European and global level are not true, and this is something which can be useful for the national level as well. On the next slide, I would like to provide an update on Directive for Temporary Agency Work. This directive was adopted in 2008 and transposed in 2011, and I remember from the time, because I've been in the industry for a long time, remember from the time that in Ireland there's been fundamental changes at that time, recognition of the role of our industry in labor markets, but then appropriate regulation and the need to ensure protection based on equal treatment, equal pay for agency workers. Since then, we had several legal cases at EU level by the Court of Justice on the need to ensure overall level of protection and on the temporary nature of agency work. These were especially the Time Partner and the Daimler case of recent years. And the European Commission organized this year a high-level conference with labor lawyers from across Europe to discuss the directive, which could be seen as a path maker towards a possible review or revision, which has been called for by the European Parliament, European Commission, European trade union as well. What are the key elements? It's the temporary nature of agency work. So in the directive, it says that we are assigned temporarily to perform workers at the user companies. The role of social partners with collective labor agreements, less the case for Ireland, but certainly of relevance to other countries. The cross-border mobility of agency workers, so workers moving from Ireland to other countries, Germany, France, Italy. The possible avenues for a better and effective directive and the overall level of protection for workers. These all, together with pressure from Parliament, has led to concerns on the employer's side, including back Europe, whether this European Commission could still act on the directive and propose a revision. This will not be the case, and this is an important achievement for back Europe, because we are not in favor of revising the directive. But we know from a fact that there are forces on the left side of the spectrum, as in the far left, as well as members of Parliament, who are calling for a revision. It's not in their main program, so nothing is confirmed yet. But also the current Commissioner for Employment and Social Affairs, Nicola Schmidt, has been in favor of a review or revision. What is certain is that partners at EU level will be consulted at cross industry and sector level to really have a say once a revision might come to effect. But at this stage, I can rest you all to peace. Nothing is in the pipeline or foreseeable for next year or the year after next. So for the time being, no real threat, but something to watch carefully in the years to come. Next slide, please. Second legal file is pay transparency, and here we are in transposition phase. What the EU Commission has found out based on research is that women get on average 13% less compared to the male counterpart, and this has led the Commission to propose regulation on pay transparency and pay equality. And this includes several elements. The first one is access to information. So making sure that the pay rates and the calculation pay rates is transparent and understandable. Reporting obligation for companies on pay differentials, on difference between pay between women and men, and access to justice for workers. So if there's an unjustified difference in pay between women and men, these should be corrected or should be tested by courts. The directive has been adopted this year, so there's a transposition phase. But there are a few issues that are very relevant for our industry. On the next slide, please. The first one is looking at the trial work relationship. There's a shared responsibility between the agency sector and user companies to ensure equality of pay between women and men based on the directive. And this requires the user companies to provide information to the agency on the levels of pay, and to ensure that these levels of pay are being defined and applied in a way that respects the directive's provisions on equal pay between women and men. Secondly, and this is even more important, is the fact that agency workers, as you all know, change their jobs, their positions, and their employment contracts much more often than other workers in the labor market, which means their assignments are shorter, their contracts are shorter, which leads to higher administrative burdens and requirements for companies, for our sector, to administer these pay transparency rules. And these are issues that we have addressed in the procedure towards the legislation, but the European Commission, European Parliament were saying that they are not willing to apply special rules for our sector to reflect these challenges. And we were not willing to accept a solution or an approach whereby we accept a longer term pay differential between women and men, because that would be not 21st century policies. So it's a bit of a difficult output there. We have developed guidance for our members, member federations across Europe, on how to enforce the directive, on what to watch out, and what to discuss with your national government. Of course, transposition is until 2026, so there are a few years still to come. But it's important to be there early because, of course, the impact you have in the consultation phase with social partners or actors. So it's important to look out, to watch out, and to monitor in the transposition phase. We have at WEC Europe level a committee of public affairs in which Brendan is a member, and we will discuss these issues on an ongoing basis, share practices among our members, and provide guidance where necessary. Of course, transposition is national, so you are best placed to monitor and influence this process in Ireland. Next slide, please. Then on platform work, and here I'm going to be a bit moving away from my slide because there was an agreement 2 days ago on the platform directive, a directive that has been proposed on the agenda for a couple of years now, the idea here was to ensure social protection for workers that are working via digital labor platforms, and to make sure that they are classified correctly as self-employed or workers, that they have access to right pay and conditions, and that they are able to claim their rights. We have a position paper on that one together with our members. We had some research being done beforehand with social partners, and we called for the need to recognize that platform work can be based on different employment models, so self-employment or worker status. And the presumption can be a useful tool, but it's important to also recognize that some agents work via platforms or online tools, and therefore it's important to recognize these different forms. Secondly, on autonomous decision making and the use of AI, we were calling for regulation that is compliant with the AI Act and with the GDPR, which is now the case, and transparency obligations should be transparent and proportionate. There was a big discussion on the classification on whether it should be on European criteria or national criteria. The answer is from the trilogue that it will be European criteria out of the set number of criteria to be applied. This is a compromise. It is a compromise our members can work with. It's not the ideal solution we as employers would have liked to have, but yeah, the assessment will be very different looking at countries, and again, a lot will depend on national transposition, so something to watch out. I can't give you now a deadline for transposition or enactment of this directive because it still has to be approved by Council and Parliament, but this will be happening in the coming months, and then we will follow up. Next slide, please. Linked to that is the discussion on civilian intelligence. And this is a discussion happening not only at European level, but also at the global level, with the EU AI Act having been proposed at European level, but also the OECD having proposed regulation, have proposed a report on AI in the OECD Employment Outlook. The AI Act is initially primarily focusing on goods and services, and it tries to address the risk linked to the use of AI systems, and it proposes a list of high-risk applications, including employment and recruitment services, which is in the final text, a set of criteria to be applied for high-risk systems, and obligations for high-risk applications. This AI Act has been approved 2 weeks ago in trilogue. Again, it needs to be approved in the final form by Parliament and Council, but this will be happening in the next month, so before the EU elections come in, and then it will be transposed directly. So there's a transition phase, but the Act as a regulation will be applied directly. And the AI Act is not the end of the story on AI at European level, because the AI Act, as I mentioned, is focusing mostly on goods and services, what the European Parliament, trade unions, and also the Commission have identified is that more and more employers are using AI for recruitment purposes. So in terms of job matching, in terms of candidate profiling and others. And therefore, they feel there's a need to propose regulation on AI in employment to address bias, to address risk of discrimination, and to ensure a fair and human-based approach to AI. Now, we at European level, at global level, have adopted principles on AI to make sure that our industry's voice is being heard. These are being reflected or taken up by policymakers, but it's something where we need to watch out in the coming years and the coming mandate, because it's something important coming into the EU machinery in the next mandate. Next slide, please. Yeah, here a bit of what we have done. So we had initial positioning on the AI Act when it was proposed. We, of course, our activities with employers federations, especially Business Europe, has been very active, but also some companies being active on the field, especially IBM or also Google's LinkedIn's of this world. We have then published our AI principles on the ethical use of AI this year, called the human-centered approach, and that the systems must be beneficial for companies and workers, and must be then in human capacities and in clear processes, as well as transparency, accountability, and traceability. We have then agreed on advocacy messages after summer, which has been put into the final phase of negotiations, but we haven't seen the final text yet, so it's too early to really assess the benefits and risks to this AI Act in the concrete legal terms, as Brendan did for the national dossiers he presented. So we'll come back to this one in 2024 with some more detailed assessment and guidance to our members. Next slide, please. That's it from my side, and I would like to thank you once again. You've had my details there. If you want to contact me, please feel free to reach out. And as said, many things are coming to national level next year in terms of transposition platform work, AI, discussions on temporary regulation, and WAC cooperation is here to help you, to support you, and to sustainable growth of our industry.
Thank you so much, Brendan and Michael. That's a hugely informative session and an awful lot to take in and a lot of complexity coming our way. Just, Michael, first question to you, if you don't mind. A lot of agencies are using apps, okay? But the definition of what platform work is in the context of the European Union's understanding of it would be very, very helpful.
It is a platform that uses a digital tool to match work and workers. So it is actually what we are doing as HR service industry in the classical context, move to digital space. And the definitions were discussed at length at the European level. The definition found is quite consistent and in line with our position. So we are happy with the result.
Super, thank you. And just to remind our own viewers here, when the Agency Workers Directive was transposed into Irish law, the Employment and Recruitment Federation went into lobby mode. And one of the successful things that we managed to achieve in a derogation or in the transposition into Irish law was the liability on the employer to give correct information with regard to the direct comparator rate of the agency candidate. So in the context of the European legislation that is coming our way, it has to be transposed into Irish law. So for us, Brendan, it's a very busy time ahead in terms of lobbying when those things come in.
Yeah, it certainly is, Siobhan, and I suppose I know I probably say this every year in terms of the stuff that we're having to kind of deal with, but it certainly does feel that we're having an unusually significant volume of labour market regulation and so on being proposed or being legislated for. A couple of kind of quick things, just even on aspects too that Michael has touched on, in I suppose from a domestic perspective. Well, for maybe just to kind of at a simplest, of course, when we talk about platform work and so on, we're not obviously talking about, you know, the well-established, you know, use of apps by recruitment agencies to moderate the relationship, for example, with their candidates and so on, and all of that sort of stuff. That you know, that's not an issue here. I think, as Michael has said, look, it's really about the moderation of employment, in which organizations or indeed individuals are using these kind of online facilities to solve specific problems or procure services in exchange for payment. And I suppose that's obviously an important distinction. And I suppose the other thing to mention is that, as if all of that wasn't complicated enough, colleagues will perhaps be aware in the last month or so of a very significant Supreme Court case here in Ireland, which was a case actually brought by the tax authorities, the revenue commissioners, in the case of Karzan, or Domino's Pizza, as it's more regularly referred to, which found that Domino Pizza delivery drivers ought to be treated as employees and not as independent contractors. And one of the critical issues that looked at was the mutuality of obligation test, which is one of the long established tests about determining employment status. And in that case, the Supreme Court disposed of the established principle that mutuality of obligation must exist before a finding can be made that an employment relationship exists. And actually, the Supreme Court has now set a new series of 5 steps to determine that issue. So questions like, does the contract involve the payment of wages or other remuneration for the work concerned? Is there an agreement under which the worker is actually agreeing to provide their own services and not those of a third party to the employer? If that's the case, you know, does the employer have sufficient control over the employee, which effectively characterizes it as an employment agreement? So those are some of the kind of key elements. So and again, look, a lot of us are trying to fully digest that and pick our way through its implication. But the point about this is that I think we're certainly seeing a narrowing of, a broadening of what has been characterized as employment, and a narrowing of that which is not. And one of the critical issues I think we have to watch for there is getting the balance right to make sure that, you know, legitimate independent contracting isn't squeezed out in the process. So that's one issue I think that's really important maybe to mention, where there's an understandable overlap between what's happening at a European level and what's happening domestically around platform work issues. And the second one, maybe just to touch on, if I may, is around this issue too of the pay transparency agenda. And I think for the sector, that increasingly will be a really important issue, because, for example, under the directive, which, as Michael says, look, you know, that has to be implemented or transposed into domestic legislation here in Ireland by June of 2026. But for example, for job seekers, you know, there's a new right effectively under that directive, where employers have to provide information about the initial pay level or indeed the range in the job vacancy notice or before the job interview. And obviously employers will not be allowed to ask prospective workers about their pay history. So that, you know, there are important changes coming around those issues. And another issue that is going to be, I believe, extremely sensitive, I think, is that there will also be an obligation under the new directive, when it is legislated for, that where the gender pay gap in an organization is more than 5% without objective justification, and if it hasn't been remedied within 6 months, there will be an obligation on the employer to carry out a pay assessment. And that assessment will have to be made available to employees and their representatives. And representatives is not necessarily limited to those that are in situ in a unionized organization. It's for all organizations. So how that notion of provision of information to representatives, I think, is likely to be a very sensitive issue here domestically in terms of the debate about the implications for those organizations who are unionized and those who are not. So I suppose the point is, there are some significant issues of implementation and all of that again, we might return to on another occasion.
Absolutely, thank you. Michael, you wanted to come in there?
Yeah, I want to come in back on platform work, because I think one important element to remind is the initial background and the initial reason for this directive to be proposed was the discussion around the Uber drivers, the delivery riders, and so on. So the idea was to protect those workers who are on a bike or in a taxi and have very unpredictable income and working schedules. However, the directive, as it being designed and proposed, also covers any other form of online intimidation of work. So it also can impact on HR services, and therefore it's important to monitor the transposition. We are not concerned that it increases obligations for our industry, but it's important to ensure a level playing field, fair competition, and transparency here.
Thank you. Brandon, we've seen lately, obviously, we've had an unusual amount of additional employment legislation coming our way and additional employer costs. And I find it interesting that IBEC, Gerard Barry, in their quarterly report, laid straight aim at the increased legislative cost of employment in this country and are highlighting it, and the Chartered Accountants of Ireland have done the same thing. Do you think that there's any understanding in government of the cumulative impact on competitiveness of all of these additional costs on employment, and particularly the complexity of this employment legislation for the SME sector? For most of us in agencies, we attend briefings like this, we're on top of it, and we're able to navigate it. But for small to medium enterprise in the domestic economy, it's just getting ever more complex.
Yeah, and I think one of the complexities about conveying the message is that sometimes the message gets confused with other data. And what I mean by that is that obviously we've had the very fortunate position over the last couple of years where, notwithstanding an increasing burden of regulation, economic performance, has really been top of the European League. And as we know, most recently from the Irish government's budgetary changes, a very significant amount of that was enabled by the very high levels of corporation profit taxation, and which of course historically has been hugely boosted by the performance of the foreign direct investment community and sectors, and particularly across sectors such as pharma and medtech. Now, the reality, of course, is, as everybody knows, for example, across the pharma sector, some of the corporate performances have been softening over the last couple of years, over the last 12 months in particular. And, there are challenges, let's put it like that, I think, about sustaining the level of expectation around the level of corporation tax that the Irish government can continue to expect over the coming years. And so I think that will have its own sobering effect. But I think the reality is that as we face into an electoral cycle, there are political, I suppose, judgments being made about where regulation needs to go. But I did say I think that a real concern that we have to keep pushing is to highlight, I suppose, the the combined effect of all of these changes, as I say, increasing labour costs of up to 10% over the next 10-year period, and the additional burdens on employers that we expect that these changes will occur. I suspect we could actually be light in making the assessment about 10%, because in fact, I was looking even more recently at figures produced by the National Centre for Productivity and Competitiveness, that actually, even before those changes come in, that between 2021 and 2022, our total hourly labour costs increased by almost twice the European average, I think by about just shy of 9.5% versus 4.5% in the euro area. So even before these changes come in, we have been starting to slip. And again, as I say, I think the worry I would have is that the full impact of these may not be seen until employers kind of cry halt, and it starts to have an impact in terms of employment creation and generation. But of course, at the moment, we're in a very tight labour market situation, and employers are having to bear these costs in an incredibly tight labour market, but in what are obviously more challenging conditions.
Well, thank you, Brendan. I think there's also a case to be made that from foreign direct investment, you talked to Michael Lohan and his statements in recent times that it's becoming ever harder to win foreign direct investment into this country, and are making it a very expensive place to manufacture at the very least.
Yeah. No, I'd agree. But again, it's about, look, there's such an obligation on all of us to just continue kind of pushing the message, bringing awareness to its implication. And I mean, for example, if you take, I suppose some of the pensions changes that we've discussed this morning around auto enrolment. Those are, if you take even just one obvious sector, if you take wholesale and retail, the retail sector, in that sector in particular, if you take the combined effect of a pensions auto enrolment system, along with the impact of a move towards the living wage, the combined effect on labour costs in that sector alone are likely to outstrip probably many other sectors. But that hasn't had huge visibility, and I just think there's such a challenge here in calling out the pinch points about where this causes real problems for real businesses, and obviously their workers ultimately in terms of the sustainability of employment. And I think that's the challenge we all face over the next kind of year or so.
It's funny, I was speaking to a shopping centre manager on Sunday morning, in early, out early, but the combined cost of the legislative changes and rights and entitlements just for a contract for cleaning for the coming year has increased his costs by €300,000. But in those kind of forward-looking contracts, people are assessing it, whereas if you're not in long-term contracts for service provision, it may just hit you, and then cumulatively, it becomes a shock. But for anyone who's engaging in forward-based contracts, those charges are already being implemented.
And again, I suppose, given that you mentioned that particular sector and cleaning and all of that, it's also worth mentioning, notwithstanding the changes that are coming in to the national minimum wage, which as colleagues will know is going to be $12.70 from the 1st of January, alongside changes to PRSI and USE. There are also legislative proposals to make it much more difficult for employers to object to the establishment of joint labour committees, which of course historically, where they have existed, and they do exist in a number of sectors like contract cleaning and security being two of the more obvious ones, but that where they do exist, they do tend to introduce effectively a second tier at a higher level minimum wage for that particular sector. But again, all of this is likely to morph in 2026 into a national living wage, which again the government has said is committed to, which is likely to be set at about 60% of the median wage, which in today's terms could be in or around 1370 or thereabouts. But again, that may well change as an absolute figure. But again, that's coming, and again, that's only well, what, 2 years away now.
Yeah. And Michael, final word to you. I know the employer group in the European Commission has a right to request a competitiveness assessment on any new legislation that is proposed. Have you found that working effectively in Europe so far? Have you come across it?
I have seen it, but I have not seen it working effectively, because every time we have new regulation being proposed in the area of employment social affairs, there have been checks being done, but they have been largely ignored because the agenda of a commissioner or commission president or a commission college has been set beforehand. And I would say it has been more a kind of we must do this exercise rather than an effective tool in terms of making regulation fit for purpose, fit for business, and fit for society. For doing so, it's even more important to have a strong voice in the capitals, in Ireland, and in Europe, to make sure that our voice is being heard, and that we are also not there alone, but we are there together with central employers and other actors to be stronger together.
Well, I very much appreciate being part of the World Employment Confederation and the ERF's position in it. So for all of my colleagues, I'd like to take this opportunity to thank Brendan and Michael for such an informative session. We will be hosting these sessions on a more regular basis, and the Employment and Recruitment Federation will be incredibly active in terms of trying to influence the manner in which the European regulations are transposed into Irish law. And I'd really like to thank Michael for his work on our behalf in the European Union, and also Brendan for his work in Brussels, in addition to his work here in Ireland, and keeping us informed and influencing as best we can the outcomes of this legislation, and raising awareness of the competitiveness issues that these regulations and these increased burdens of employment are causing. So to all of you, I hope you have a great day, and thank you very much for your time this morning. We look forward to hosting you again soon. Thank you.
Thank you, everybody.
Thank you. Bye-bye.